Well, good afternoon, everybody. My name is Steve Shiro. I'm on the board of the Apartment Association. Would like to thank you again for coming to our trade show. Really appreciate it. Hope you've gotten a lot of great information. You're about to get some really good information about some of the upcoming laws, eviction information, etc., from Mr. Block. So without further ado, I'm going to give you a little background on him if you haven't worked with him or if you haven't heard him before, and this will help you understand what a valuable resource he is for all of us. So Attorney Dennis Block of the law firm of Dennis Block and Associates specializes in tenant eviction. The firm started in 1976, exclusively represents landlords in tenant eviction cases. Dennis has successfully performed over 175,000 evictions. His clients range from the federal government, municipalities, banking institutions, real estate management companies, and of course, mom and pop income property owners. Dennis is dedicated to serving the legal interests of landlords and income property owners whose properties are in the state of California. He received his bachelor's degree from the University of California, Northridge, earned his Juris Doctorate degree from Whittier College School of Law. Dennis gives numerous seminars to attorneys, real estate groups, landlords, and he has a weekly radio show every Tuesday at 11 a.m. on KTYM 1460 AM radio. He is also a rental property owner. So without further ado, Mr. Dennis Block.
Thank you. Everybody hear me? Welcome. By the way, on that radio show, they sold the station. So I have to update this. But everybody can go to my website and hear my podcasts. Yes. My name is Dennis Block, and 42 years ago I started a law practice. I started it on a shoestring budget. I borrowed a typewriter from my best friend's father. And then my practice went into a tailspin because the father wanted the typewriter back. Fast forward 42 years, and I find myself with 19 attorneys. I'm so old, ladies and gentlemen, that 2 of those 19 attorneys are my children. I have Madison in the booth with the expensive clothes she's wearing. I don't know where she got it. My other son is battling in court, and I also have my third son, Brandon, my third child, who's in our booth, deals with our collection issues on collecting judgments against the judgments that we get against these tenants. If anybody's ever used our service, they know that if you just merely call my office, 1-800-77-EVICT, you know that you're going to be able to speak to an attorney. And whether you have a case with me or not, we're happy to answer your free legal questions at no charge, your legal questions. And I'm sure there's people in this audience who have taken us up on that. Anybody's called my office and gotten free legal help? So please feel free to do that. I have a website, which is evict123.com. If you go there, you're going to see all of our podcasts, our free forms, legal issues. Everything is free. Advice is free. Forms are free. I don't even know how I make any money. Honestly, it's surprising to me. If anybody wants to know, I know that the burning question that most people are asking themselves right now, the burning question would be, how the hell do I look so good? How's that possible? 42 years and I still look like this? Well, I will tell you my secret real quick. I get up at 3 a.m. every morning, except for the weekends. I am at the gym at 3:30. I am at the office at 5:15. I don't take a break, I don't leave for lunch, and I leave at 4. That's my life. And I enjoy what I do. I do have, if anybody ever needs to get me, immediately without going through our normal phone line, just call the office and hit extension 101. only for the people in this room. You'll get me without a receptionist. However, you can only use that extension between the hours of 6 to 8 a.m. If you call me 6 to 8 a.m., then you will certainly get me. This reminds me of a story about a man who walks into a bar and orders a shot of whiskey. He downs it in one gulp and then takes the shot glass and slams it on the bar counter. He turns to the crowded patrons in the bar and he says, "I think all attorneys are idiots." Well, a guy walks up to him and says, "Hey, I resent that." The guy says, "Why, are you an attorney?" He goes, "No, I'm an idiot." I don't know why they hate attorneys, but that's just the way it is. Okay, for the last 2 years, I've been running around this state trying to defeat Proposition 10, which was going to open up rent control for all these jurisdictions, and we worked so hard, and we did what we were supposed to do, and we defeated Proposition 10. And therefore, what the hell happened? What happened? All of a sudden, we're having statewide rent control. Don't the politicians hear what the voters voted on? 2/3 to 1/3, we beat Proposition 10. And then the legislature says, "I don't care. I don't care at all." So what did they do? They have voted on and enacted statewide rent control. So if your property wasn't under rent control, it soon will be. They're just waiting for Governor Newsom, may he rest in peace, to sign. Well, because, he wouldn't sign it then. He will sign it, and then we will all be under rent control. So if you were in the beautiful county of Orange, which doesn't have rent control, you had property in Manhattan Beach, Redondo Beach, I don't care, Torrance, wherever you have your property, Lancaster, Ventura, it doesn't make any difference. You're now subject to rent control. And that's what this is going to do for us, right on the screen there. So what is this rent control going to do once the governor signs it? It's going to put a cap on rent increases. So we're going to be saddled with 5% plus the CPI per year. One rent increase, 5% plus the CPI. Generally, the CPI has been about 3%. So if you add those two figures together, you're going to be entitled to an 8% rent increase. Why on earth do they single out landlords from any other person in business who sells goods or services? If I wanted to charge $10,000 an hour for my services as an attorney, I would have the right to do so. I might not have any clients, but I certainly would have the right to do so. If I want to sell furniture and I want to sell a couch for $400,000, no one can come in and tell me what I can sell it for. But of course, really, someone does come in, because you see, the market controls the price. The market controls the price. Nobody can sell anything for more than it's worth. You ever tried to rent an apartment? You go, I'm going to get $2,500 for that apartment. I said that to my management company. And let's try. No one called. Okay, let's lower it to 24. No one called. Lowered it to 23. Finally, 22.50. You see, because that's what the market bears. And the market will determine everything. However, some people have a different understanding of the word economics or a free economy. And they want to put price controls on just one segment of society. Just one. Now, rent control should really be called tenant welfare, because that's what rent control is, right? And like with social welfare, at least you have to qualify for it, right? You have to show you demonstrate a need. You know, my husband is infirm, my kids, whatever the story is, you have to show. In addition, if you do qualify for social welfare, it's not one person paying, it's the entire populace through our tax dollars. But you see, with tenant welfare, which is what we're talking about right now, you don't have to qualify. You could have just closed a $40 million real estate deal, and if you're in a rent-controlled apartment, you are entitled to that rental protection. Where is the fairness? At the very minimum, it should be you should at least have to qualify for this welfare. And then you're in a situation where with social welfare, everybody's chipping in, but in our situation, it's me. I have an apartment building where I just rented out a 1-bedroom apartment in Studio City for $1,795. I have an elderly gentleman, very nice person, I have nothing against him, and he's paying $897. So I am every month contributing about $1,000. Why do I have to do that? Where is it written in the law, in our Constitution? But that's what we're faced with. But I want everybody to understand what rent control really is, and don't let the media gloss over it in such a way like, oh, this is a fair thing to do. No, it's not a fair thing to do. It's a symbol of the degradation against our free economy, and it's tenant welfare, and it's asking one person to support another person, which is just redistribution of the wealth. That's it. Or redistribution of my labor. My labor goes to you. I get up early in the morning, but yet I'm contributing $1,000 to you every month. So we're faced now with every place being 5% plus the CPI 1 increase per year. Now, a lot of you people are thinking to yourself, wait a second, Dennis, I'm for this state law. Because you see, I got property in Los Angeles. I'm already saddled with rent control. And the most I could get this year was 4%. Bring on state rent control. Now I can get 8, right? No, it's not the way it works. If you're already under rent control, then the state law has nothing to do with you. Your local rent control ordinance applies. So it's not like you're going to get a gimme for more money. So this is only affecting those areas where no rent control exists, So there are exceptions. If you have a single family home or a condominium or a townhome, those are not under rent control unless you are a corporation that owns multiple of those types of units. So the normal person who's owning a condo, a townhouse, you're renting it out, or a single family home, and you never were under rent control, you're not going to be under rent control by the statewide ordinance or Assembly Bill 1482. Also, if you own a duplex and you live in one side of the duplex, that's also exempt. So owner-occupied duplex are exempt. Now again, I want to emphasize, we're not talking about Los Angeles or West Hollywood already has rent control, or Santa Monica. We're talking about if your building in Anaheim, Santa Ana, okay, Redondo Beach, all these areas, okay, if you weren't under rent control, you are going to be under rent control. When I was talking to this group last year, I said, even with Proposition 10, we don't know what's going to happen. And I advised everybody, if you heard me last year or any of the other seminars I did, I said, whatever you do, raise your rents now to market level. I said that. I said also, not just raising the rents. I said to you guys, if you have a malcontent in your building, and what's a malcontent? That's somebody who just gives you a hard time and he's paying full rent, but he's on a month-to-month tenancy, get rid of him now, because once rent control starts, there's something called good cause, where you're going to have good cause to evict. So the guy can basically be a rude son of a bitch, but you're not going to be able to get rid of him. So I advised everybody, and I had a lot of people come over to my booth right now and told me that they took my advice, and now we don't care about this statewide rent control because My tenants are nice and I'm getting max dollars or at least market rent. By the way, there is no such thing as rent gouging. When they tell you that all these landlords are who can gouge rent? Remember when I tried to rent it for $2,500? I couldn't do that. You know, maybe if there's an earthquake and some guy at the 7-Eleven is selling a bottle of water for $50, maybe in that situation that's gouging. And by the way, if you really want to talk about gouging, if you really want to talk about gouging and where there should be price controls, I went to the food concession booth right here, and I didn't want to use a credit card. I got a Diet Pepsi. So I pulled out $5 out of my wallet. I just didn't want to use a credit. $5.50. $5.50. You want to talk about price controls? Where's Governor Newsom? Bring him down right now. That's no, but you see, they have the right to do that. They do. They can sell it for $40, and I probably wouldn't have bought it, right? But I figured I needed to be hydrated because I'm giving this big seminar, so I figured I better spend the $5.50. So I did pull out my credit card. But that's gouging, at least on one level. But they have the right to do it, but not us. Okay, so it is exempt if in fact it's an owner-occupied duplex, condominium, single-family homes, or townhomes. Also, if your building would be exempt under this new state rent control if it received a certificate of occupancy in the last 15 years or 2004. So why did they do that? That they made it like for the last 15 years, like new construction wasn't going to be touched? Because they're in their brain, they're saying, well, gee, we want to encourage people to be developers and develop new property. So they kind of exempted the last 15 years. But what the morons in Sacramento do not understand was there already was a law, Costa-Hawkins, that we kept alive because Proposition 10 wasn't voted in, which said that it's all exempt if it was built after February 1995. So they just eroded that. So if I'm an investor thinking about developing property in the state of California, the fact that they're limiting it to the last 15 years, that doesn't give me any hope, because I know the next group of legislatures can just make it the next 5 years. So it's so silly what they're doing in terms of their housing crisis. Housing. What's the housing crisis? The housing crisis is that the building regulations are so strenuous, you can't build. It costs you so much more to build. And all the red tape and delays and the getting of the permits. You ever built anything? That's what creates the expense. And guess what? No one's going to build something without trying to get a return on their investment. So of course rents are going to go up. So if you want to have rents go down, supply and demand, make it where it's easier to build units. But of course, I'm not running for office. Of course not. Also, landlords cannot evict under this new law unless you have just cause. Just cause is similar to like what's in Los Angeles, where you don't pay the rent, you're creating a nuisance, you bring a small Shetland pony into the unit where the rental agreement prohibits pets, so those types of items. The only problem with that is when you have a nuisance tenant, for example, you know, they're screaming and yelling throughout the day, they're having toga parties, music blaring, urinating out the window. I don't know what these people are doing, but every person in the building is complaining about these idiots. So if you need good cause, no problem. You're gonna do what? You're gonna do what? You're gonna call me. Of course you're gonna call me. Why do you think I'm standing here? Why do you think my 1-800 number is up on that brochure? Okay, so then you're gonna call me and I'm gonna say, sure, urinating out the windows, that's a grounds for eviction. And I'm saying, but we're gonna need to have some witnesses. You know, well, I can't get the other tenants to come. They're afraid of this guy. They don't want to get their car keyed, right? So it makes it much more difficult, specifically in a nuisance situation, to have other good tenants come to court. So normally what happens, like what happens in Los Angeles, is the good tenants leave, and now you're stuck with a building of bad tenants, okay? So it makes it much more difficult when they're putting in this good cause, but that's what you're going to be faced with right now. Also, this bill is not going to be effective until January 1st, 2020. So if you were real smart and your rents were low, what you would do, obviously, since we're in the month of September, is to serve a quick 60-day notice. Let's raise the rent, get it to market value, and we are saved. Correct? No. Reason why we're not saved is because they're going to they're going to roll back the rent to March 15, 2019. So if you raise rents after March 15, 2019, and you raised it above the permitted amount, which is going to be about 8%, 5% plus the CPI, you're going to have to lower it back to what it was come January 1st. So that is not going to help you by raising rent. Certainly raise it, no question, raise it. If you're happy with 8%, raise it, and then you're okay. But if your rents were so far under market value and you never listen to the advice that I've been giving for the last 2 years, you're somewhat stuck. Or are you? Are you stuck? Do we have some things that we can do to save ourselves? And that requires a click. And there we go. Ways to survive. So how are we going to do that? First of all, and primarily, what we need to do is to understand that we're going to need good cause to evict tenants after January 1st, 2020. But we don't need good cause now. Let's see. If a tenant has been in the property for longer than 1 year, we need to serve a 60-day notice. Well, let's see. If I serve a 60-day notice, is that going to expire before January 1st, 2020? So right now, what I'm advising everybody to do, if you have a malcontent in the building, that would be a person who's calling you constantly. Every other tenant calls you about something broke, maybe once a year, once every day. This guy every week. I don't know, a light bulb went out. There's a crack in the wall pipe. I hear it chirping outside my window. You know, you just want to kill these people. So if you've got a malcontent in your building, let's issue a 60-day notice. Now my firm has been doing a special notice to quit, which allows the notice, the tenancy to be terminated as of November 30th. By doing it that way, we get to keep October 1st rent and November 1st rent. So we've been doing a notice to quit that gives that, and we've been doing a lot of this. If you want us to do this for you, of course, you can call our office. But in any event, we need to serve 60-day notices now if we've got malcontents or we've got low-paying tenants. Because if you're happy with an 8%, no problem. Guy's a nice person, looks like Mother Teresa, perfect, okay? I'm happy with 8%. It's fine with me. I'll get another 8%. That's fine. I don't want you to start issuing notices, 60-day notices to all your tenants. But if you've got low-paying tenants, or you've got a malcontent, you've got such a small window of opportunity. That window of opportunity will end around October 28th. And you don't even want to get close to it. Because if you serve a 60-day notice on October 28th, it kind of ends like around December, end of December. And therefore, the new law hasn't kicked in yet. So, everybody here is saved. Because don't forget, like I own a lot of property in West Hollywood. And they give me a lousy 0.5%. I think this year, they raised it to 1.5%. Whoopee. But you see, my rents are about $3,500 for a 2-bedroom apartment. I don't care. I'm happy with it. Nice tenant, $3,500. I'll take 1% because my rents are sky high, or they're really market value. So if you can get your rents to market value, you don't care that much. Yes, we don't like the intrusion of government in our pocket. Yes, I want to be able to evict anybody who I want to if they're on a month-to-month tenancy. But unfortunately, in this liberal state that we live in, sorry if I stepped on your toes, but then they probably deserve to be stepped on. At least we can get our units to market value. So right now, if you had that wonderful apartment in Santa Ana, or you name the city, in that situation, we can serve a notice to quit. Right now, we remove that tenant, and then all new tenants coming in, you could raise the rent to whatever you like. Once you establish that tenancy, you're going to be stuck with once per year, the 5% plus the CPI. Very, very important. You've got a small window of opportunity. Tell all your friends, okay? Now, let's move on. Point number 2. Lease units with a maximum of 6-month lease? Why the hell would we do that? I always rent by the year. Makes sense. I don't like giving month-to-month tenancies. I want to have a tenant be there at least a year. No. What do you mean, no? No, you don't want to do that anymore. Why is that? You see, the way the law is written, the state law, and again, we're not talking about property that's already under rent control. That's not my topic, okay? If you have property that is not under rent control, but will be under rent control, if you rent out a unit, you only want to rent it out with a 6-month lease, not a penny more, or a month-to-month. And the reason for that is, under the new rules, it says that you need good cause to evict the tenant unless they've been there, they have to have been there for at least 1 year. So if they've been there for 1 year and now they're having the toga parties, right? And you now have to bring in all the other witnesses, which are difficult to do. But if you rent it out for 6 months, you got a 6 months to kind of see how the guy is, right? You know, these tenants, they're so funny. You rent to them, I mean, right, everybody has the same experience. You rent, they're the nicest people. They're holding the door open for you, they're being so polite, everybody's loving, you know. And as soon as the ink is dried on the contract, it's like it's Attila the Hun. What the hell happened to you? Oh, I see a little piece of mold on my floor. So I don't know. You know, and they're so demanding, these people, and they come in so nice. It's like they're really out of their minds, but somehow even people who are out of their minds can hold it together during that leasing period, you know? So you want to rent it out for 6 months. Why? Because after the 6 months, it's still less than a year, and by then you've kind of seen the way they are. People will tell their true colors, you know, within the first year. Have anybody ever been married? Just kidding. Just kidding. My kids are here. So after the 6 months, if you're saying, I'm done, and I'm going to issue you a 30-day notice, since they haven't been there for a year, I don't need any cause, get the hell off my building. That's the second point with this new law. Only rent it out by a maximum of 6 months. See how this person is. Is he a good kisser? Is he nice? Does he caress? Does he bother you? Does he pay his rent on time? This is what you want. I kid you not, ladies and gentlemen. Okay, let's move on. You didn't listen to me. You've been in a coma. The 60 days have come and gone. Now you're under rent control. Your rents are low. We're on point 3 here. Your rents are low. You're stuck. And now all of a sudden, your kids are screaming at you. Why are your kids screaming at you? Because they're going to inherit your property and they're going to say, what the hell did you do to me, Dad? You left me with this Ocean View apartment for $642? You couldn't raise the rent? You didn't listen to Dennis? Why did you do that? Now I'm stuck. It's January of 2020. I need good cause to evict. I can only raise it a lowly 8% for a $642 Ocean View apartment. Are you out of your mind, Dad? I go, yes, because I wanted to punish you for all the stuff you... No. So there's an out, even in that situation. If you're going to do substantial renovation, I don't know what substantial means. They haven't really described it. Does that mean that you, I don't know, you paint the bathroom wall? Is that substantial renovation? It is to me. But if you're going to do substantial renovation, then you have to pay the tenant relocation money. Oh my God, is it like Los Angeles where it's $10,000 to $20,000? No, it's only 1 month's rent. So nothing about this is good. I'm just telling you that there's a way to make it better. This whole state thing is an abomination, and the people's feet should be put into the fire. But if I claim I'm doing substantial renovation, then I have to pay 1 month's rent, or you can allow the tenant to just live the last month for free, and you have a way of getting rid of them. Well, that's pretty easy, right? I think it's pretty easy. How many times does a tenant leave a unit that you really can't do some renovation on the unit? Come on, we all do it. Put a little new cabinets in. We're doing one in, we're doing a family duplex. I can't even believe how much money we're putting into this, $400,000, but hadn't been done, nothing had been done for 40, 50, 60 years. And the rents were like $995, and now we're gonna get close to $5,000 near La Cienega and Melrose in the Los Angeles area. So, but you're gonna do renovation, and even if you're not, do it anyway, because now you've evicted the tenant, you've given him his 1 month free, and now you can now rent it for market value. But then of course you're under rent control again, so make sure you get the right market value, okay? Also, when you rent out units, just to give yourself some protection, because let's pretend that the unit has just been recently renovated and now the guy's acting like an idiot and he's been there longer than 1 year. You need to have something else to protect you. You can't claim, oh, I'm renovating the unit, it just was renovated. And that is, when you do rent out units these days, rent out the parking separately. I have a parking agreement in my packet here or on my website where all my forms are, and they're all up to date. Rent it out. Let's pretend you want to get $2,000 for your unit with parking. So what I would do is I would say the apartment goes for $1,900, $100 for parking. You have two separate agreements. And this way, notwithstanding the fact that you can only get 8% on your unit, that's 5% plus the CPI, with regard to the parking, parking has nothing to do with residential property. Parking is commercial. So I can take your parking spot away if I want to be vindictive. I could raise the rates on my parking for you. So it just, and you're not necessarily going to do this, but trust me, if you got somebody who's really under your skin, who's just creating all sorts of problems for you, it gives you a lot more power if you have separate parking agreement. So those are the issues in terms of how to survive the statewide rent control. Right now, issue a notice to quit or a 60-day notice, to recap. If you don't do it right now, then you're happy with the situation. And trust me, you're happy. I wouldn't, if I had the ability to get rid of the tenant in my West Hollywood apartment for $3,500, I wouldn't do it. I'm happy with that rent. It's market rent. You want to make sure that you only lease pursuant to a 6-month lease or month to month, so that during the trial period of the marriage, if you don't like this person, you can serve them with a 30-day notice to get the hell off your property. Again, we want to remember the fact of substantial renovation, whatever that means. They didn't really define it. And if you do, give them 1 month's rent. And last but not least, that parking agreement. So these are the initial tricks that I have found by my research of a law that is yet to be signed in, but maybe Newsom is signing it today as we speak, who knows? But these are the initial things to protect yourself from this new law. Now that I've gone through that, let's move on. It's another click. You know, we do a lot of evictions. And They said I've done 175,000 evictions. That is really not accurate. I've done over 200,000 evictions in my 42-year career. And if you think about an eviction case, because this topic is how to do a successful eviction, it reminds me of a play. I hate to go to plays. My wife drags me to play. Normally when I go, I'm just, oh, please. Then usually what happens is at intermission, and I like to call it halftime, because I'm a sports guy. I go and I sleep in the car because I can't stand it. But at least I went for half, okay? But if you think about a play, you're sitting there before it starts and the curtain is closed. And then all of a sudden the music comes on, the curtain opens, and you see all the actors and they're in their costumes, and you see all the lighting and you see all the stage production, right? Now, did that just happen right before the curtain opened? It just happened right before? Or were there really months and months of planning that went into the costume designs, the staging, the practicing of their lines, the music, all that stuff? That happened in months. Well, guess what? We can do our eviction cases just like that, because really we want to have the best play on the planet, because that's what we do when we walk in the court. And you see, we have a luxury as being a plaintiff in a lawsuit, the one who brings forth the lawsuit. When you're a defendant, or you're the one getting sued, you don't have any warning. It's not like you say, please sue me, sue me. And then someone says, okay, you want to be sued? Yes, I want to be sued. And then they sue you. It doesn't work like that. You're minding your own business and all of a sudden someone drops a lawsuit on you. There's no preparation, right? It just happens. But you see, we as the landlords in an eviction action, we can stage this stuff. We can make ourselves look like the White Knight, right? So, how do we do our staging? Well, the first thing is when we rent out a unit, we want to take pictures. Take pictures of your units. I even say take pictures of the common areas of the property. Take pictures of his assigned parking spot or her assigned parking spot where there's no oil drippings. Take pictures. In fact, you can even take movies. You can do it right on your phone. Anybody here have a stupid phone? Okay, you guys, I can't help. But for the rest of you, with the smartphones, you can take pictures, you can take movies. It's, by the way, it's unlimited storage if you use Google Photos. Did you know that? Video man, did you know that? Yeah, limited storage on Google Photos. So you don't have to pay for it. So take pictures of everything, because you know when they leave the unit and you walk in, oh my God, what happened to the oven door? And they go, oh, we never had an oven door. Are you kidding me? The cupboard doors, all the windows are broken. What happened to the screens? I had a faucet someplace, right? So in that situation, you have photographic proof. I've even got videos. So this is really good, especially with that security deposit itemization when they're claiming that you didn't give them enough money back, those bastards, right? But it's also really good when the tenant is telling you what a slum I am being rented in a court of law. Oh, really? Oh, I don't have this, I don't have that. All this stuff was missing. Oh, really? And then in a court, we can show the trier of fact, the judge, we can show the pictures. Look at this beautiful place. Even if we're doing a jury trial, let's show this to the jury. Look at the nice place we rented. Okay, that was 6 months ago. Look at it now. Who do you think created the problem? The landlord, which he's calling the slum landlord? Quite frankly, this is a slum tenant. That's what there should be a phrase for, slum tenants, because that's what they're doing. Take pictures. Also take pictures after they vacate, because that's also great when they sue you in small claims court because you didn't give them back any of their security deposit, right? Okay, so pictures are very important. We all have smartphones except for those 2 people. I'm going to see you after the show. I have a phone contract I can get for you. And we're going to take pictures and we're going to keep them for forever because we're going to get this app called Google Photos. And we're going to have them. Or you can, even if you have Amazon Prime, it's unlimited. Okay? All right, let's move on. If you rent out a unit, you got to rent it out with a rental agreement. Makes sense? There's got to be specific terms in your rental agreement, not that the rent is just payable on the 1st of each month. You want to have specific terms that will help us in terms of staging our eviction case so that we look like we knew what we were doing. So the first item is there has to be a phrase in the rental agreement that says all repairs must be in writing. All repairs must be in writing. Every time I've evicted a tenant for non-payment of rent, every single time where the tenant contests the case and files an answer, and in the answer he describes why he's not paying the rent. And they all do the same thing without hesitation. And that is they claim that there's problems with the place, it's uninhabitable. And they check off all the boxes. There's roaches, there's rats, there's mold, there's no hot water, there's no locks that work, the windows won't go up, every single thing. And then what I do, since I represent the landlord, I have to mail them a copy of the answer. And every single time, the landlord, my client, calls me back panicked. What the hell is this? I never see any of these things. He never told me about this stuff. This is crazy. I mean, I fixed one thing as he told me, and that happens in every single case. Either the condition doesn't exist, or the landlord was never told. And I don't know how many psychic landlords that there are, but you have to be told to fix something. But you see, what happens is the tenant doesn't have the money. And that's the reason why he didn't pay the rent. And then he has to find something wrong with the place. And if there's nothing wrong with the place, what the tenant will do is he'll break it himself. And then he'll call the health department or he'll file the answer saying all these things are wrong. So I actually have a form letter that goes out with the answer that I send to my clients and said, I understand he's going to be talking a lot about things wrong with the premises. We know that he didn't tell you or they don't exist, so please don't panic and please don't call me. So we try to cut down on the phone call. Because otherwise, they're like on the cliff, these landlords, when they see this, like, what the hell? So we want to show that we want repair requests in writing, unless it's an emergency, the place is on fire or there's water cascading out of the unit, right? We want to have this in writing because when they come up with this garbage and we're in a court of law, I will explain to the tenant, well, pursuant to your rental agreement, on this laundry list of problems, you were supposed to write the landlord a letter. Could you show me those writings, please? You don't have any? Well, that's interesting. All these things came up, and it's prominently in your rental agreement that you have to do repair requests in writing. And you didn't do it. So again, we get the credibility of the tenant to look like what it is, a guy who doesn't have the money to pay the rent. So we want all repair requests in writing. Now within the next, I'll give you guys some news. In the next month or two, I think I'm planning this out. I'm going to have a free service where you're going to be able to direct, at no charge, you direct your tenants. You're going to have your own login to a website, which is going to be repair requests. Actually, it's called requestrepair.net. That's the name of the website. It's kind of up, but not really up right now, so don't use it. It's kind of temporary until my programmers work it. But it's going to allow you guys to direct your tenants, if they want, to this website. So we're going to have physical evidence that in fact that they did make that request and what you did to fix it. It's also, you're going to get an email on that you got a repair request, and I'm also trying to do it where you'll get a text too. So you'll know that, oh, I better check my email because the guy in apartment number 2 is complaining. So look for that on my website. If you're on my mailing list, which by the way, go to my website, go down to the bottom, put in your email, and you'll get all my news regarding new developments in the law, also my seminars, and also when this website is available to you. Okay, the next thing you want to have in your rental agreement is that you're requiring the tenant to have renter's insurance. Renter's insurance. You want to have them do that because if in fact you had a situation where a pipe burst in the ceiling, water cascading into the unit, and I don't know why it always is, that a tenant always has a $10,000 Persian rug. Why is that? Every single time there's a disaster in a tenant's unit that the tenant didn't cause, why is it that he has a $10,000 Persian rug? I don't get it. But they all seem to have it. So the guy's going to want to be compensated for his loss, and quite frankly, it wasn't his pipe, and he didn't break it, and his $10,000 Persian rug is ruined, right? So he's going to ask you to compensate him, and you're going to say no. And then what he's going to do, he's going to sue you. He's going to sue you in small claims court or someplace. And then you're going to be able to absolve yourself from liability by saying, Your Honor, under paragraph 17 of the rental agreement, my tenant was supposed to have renter's insurance. And it says under this paragraph, and by the way, I have this as a change of terms of tenancy in the packet, or you can use my rental agreement, which is in the packet. So even if they're there, even if it's rent control, you can serve this change of terms of tenancy to require them to have renter's insurance. I don't care whether they get it or not. I just don't want to be sued, right? So you're going to show the judge that it said he was supposed to maintain renter's insurance, that that insurance was the sole way of being compensated if any damage to his personal property, and that he says that he will not sue me. That's what the paragraph says. So if you say that to the judge, are you going to win? And the answer is no. You're going to lose. Why? Because landlords always lose in small claims court. It's just the way it is. But in all seriousness, you'll have the best chance of winning if you have that in your contract. But there's another reason why you want the tenant to have renter's insurance. You get a report that you got termites. God damn it. And then not only do you have to pay the termite company, but you got to tell the tenants to move, at least temporarily, 3, 4, 5 days, I don't know. And the tenants are going to say, yes, I understand I have to move. I'm going to try to accommodate you. But I need, housing, And if you're like my daughter, it's not any kind of housing. It would be, the Four Seasons. Maybe the Ritz-Carlton for her, okay? And of course, she's not going to be able to do her laundry, so you have to pay for her dry cleaning, right? And she also likes to take massages at noon. She can't use her apartment, so she's also the massage at the Ritz-Carlton, right? And the tenant who you're asking to move for 3 days is going to be asking for all this compensation. I mean, right? It's not his fault that he has to leave, and you're making him leave. But we have a rental agreement. And the rental agreement says you have to have renter's insurance. And renter's insurance also provides that if you have to temporarily vacate the unit, that you have to apply for your own insurance based on your renter's policy. And that will be the sole compensation for any housing, for any food, for any medical emergencies, for any cleaning. Keep adding onto the list because I'm not paying for it. And that's the reason why you desperately need to have a requirement of renter's insurance. Again, I have this in my rental agreement, or you can do it as a change of terms of tenancy. It's legal under statewide rent control, West Hollywood rent control. I don't care. It's legal, okay? So be sure that you maintain that renter's insurance. The other thing that you want to have in your rental agreement is you want to have an attorney fee limitation. In all rental agreements, it generally says that if you file a lawsuit against your tenant, like in an eviction, that the prevailing party is entitled to reasonable attorney's fees. That's what it says. And that sounds pretty fair. If I win, reasonable attorney's fees. If you win, reasonable. But the problem is, if for any reason it goes wrong, the people on the other side who are trying to bring forth jury trials? Yeah, jury trials. And you're going to see it now happening with rent control all over the place. You're going to see it all over the place, you know? You want to make sure that if you lose the case for whatever reason, if they ask for attorney's fees, they're going to ask for $20,000. And you're going to be stuck with $20,000. But if you had a limitation in your rental agreement that says the prevailing party is entitled to reasonable attorney's fees not to exceed $500, then in that situation, you'd only be responsible for $500. But yes, Dennis, what about if I had won the case? I would have gotten $20,000 in attorney's fees against my tenant. Yeah, the tenant who's not paying you rent, the tenant who has no job, the tenant who's going to be on welfare or filing bankruptcy, that tenant, trust me, you're going to get a piece of paper with $20,000 on it saying judgment, but you're not going to actually physically get the money, and it's not worth the risk. I can tell you every categorically of anybody in this room, if I had a judgment against you for $20,000, I bet you I'd be able to collect, because you guys are rich landlords, right? So it's different. So you want to make sure that there's a limitation in your contract with regard to attorney's fees, making it $500. Again, change of terms of tenancy is legal as long as they're not on a lease. And also you can do it as just a beginning in your rental agreement, okay? Let's move on. There's a new trick that tenants' attorneys are doing now to win their cases. It's insidious. And the way the stupid legislature wrote the law, judges are forced to interpret that law in the most idiotic ways. But that's kind of what the law says. And these tenants' attorneys are using this to kill landlords. Kill them! So, this does not apply if you rented to your tenants. Okay? If the tenant in apartment number 2, you were the one who leased to them, you can just rest right now. You don't have to listen to anything more I'm saying. But if there's any tenant that was already a tenant when you bought the building, then you've got to comply with this change of ownership. You have to send your tenants, when you bought the place, a notice that states your name. You have to have a physical address where you can be served. Well, can't I just use the FedEx address? No. P.O. Box? No. But I don't want them to know where I live. I don't care. The law says that they have to have a physical address. Can you put your brother's address down? Yes. Why? Because you don't like them. But that's legal, as long as they have some address, a physical address, okay? You also have to put your telephone number down. They have to have a phone number, which means, based on the California legislature, if you don't have the wherewithal to have a phone, you can't have tenants. That's what that means. No phone number, no tenants. In this state, nobody ever thought that out, but I sure look at it that way. You got to give them a phone number. Does that be your phone number? No, it could be your property management. It could be your brother again. Let him get bothered in the middle of the night. Who the hell cares? You also have to have on this letter to your tenants times and dates when you can be contacted, like Monday through Friday, 9 to 6. Obviously, he's going to call you at midnight if there's a flood in the unit, but you have to have the times. And you also, if you're any kind of a savvy landlord, and you'd be pretty stupid if you didn't do the last one, you have to tell them where to pay the goddamn rent. And so that's an address. A lot of landlords, or many landlords say, oh, I'll pick it up. No, no, and no. Can you have a rent collection box on the property? Yeah, I have that in one of my buildings. But you have to have an address where the tenant can go. Can it be a P.O. box? Yes, that can be a P.O. box. Okay, can you have them directly deposited into your bank? Yes, you give them the account number, you give them an address of the bank, and the name of the bank, and the hours of the bank operation, you can do that. So they direct deposit into your account. Can you make them pay electronically on some website? The answer is, yeah, you can do that, but you also have to have an address as well. So make sure you have that. So why am I talking about this? So let me tell you the bastardization of the law. You have a tenant, you bought the building 5 years ago. The tenant, you never sent this letter. The tenant for 5 years has come over to your house and paid you the rent. He knows your home address. He knows your phone number, okay? And what defense attorneys are doing in unlawful detainer cases is they're saying, you can't, under the law, you can't demand rent unless you serve that letter. It's been 5 years. Are you out of your mind? The guy has paid me for 5 years. We're now September, I served a 3-day notice, and you're telling me because I didn't serve that letter 5 years ago that my whole case is lost? Yes, that's what I'm telling you. And it's happening. Okay, we're under appeal in one case where, and this was crazy, there was a management company, we'll call him XYZ Management Company, who was representing Mr. A. And all the rents were paid to XYZ Management Company. And they had their address, and they had their phone number. They were in writing, they did every little thing. And then A, one day, decided to sell the property to Mr. B. And Mr. B said to Mr. A, hey, I'm not really good at managing. Who do you use? Oh, I use XYZ. And he goes, fine. So the management company took on a new client. But from the tenant's point of view, they were still paying the same management company. They were still having the same phone number. That same letter that was served to them when A owned the building is exactly the same thing true. The judge looked at it and said, there was a change of ownership. Well, yeah, there was. And even though there was a change of owner, even though the same person is the one collecting XYZ Management Company, the judge ruled against us. I am appealing that decision. However, if you think about it, was there a change of ownership? Yes. And under the law, if there is a change of ownership, you have to send that letter. Well, that's not what the intent of the law was. And if you read the legislative intent of the law, it says it wasn't. But they wrote this law so crazy that it's killing landlords. So right now, ladies and gentlemen, for every tenant that you have, that you didn't rent to, send this letter. And you can say, just wanted to remind you in case you didn't have this, that here's my name, here's my address, and the tenant's going to go, you live right next door to me. Are you out of your mind? Yes, I'm out of my mind because I heard Dennis Block. So, is that right? No? Is that wrong? I said that wrong? Okay. All right. So be sure that you send this letter right now to every tenant that you didn't rent to. Now, if you already sent it when you first became the owner of the building, you're fine. But if you haven't, then what's going to happen is that you are going to potentially lose the case if there's a smart attorney on the other side. And these attorneys on the other side, they think they're so smart. The issue is that they can do 14 things wrong, but if they find one little crack in your case, you lose. We call them gotchas. They gotcha. So there's like 14 little gotchas. So we have to go through the checklist with everybody, and that's one of our checklists now, that the way the courts are now interpreting that statute there. So please, If you haven't rented to the person, but he's now your tenant, you need to send that out to them. You don't have to make it fancy, just make sure that he gets it. Reminds me of a woman who was walking with her daughter in a cemetery, and they come upon a tombstone, and it says, "Here lies an honest man and a great attorney." And the little daughter says to the mother, "Mom, did they bury two people in this plot?" Why do they hate us so much? I don't know. I just don't know. Okay, let's move on. Unlawful detainer, that's what I do for a living. Over 200,000 unlawful detainers, 200,000 happy clients that got their place back. I'm kind of a property rights kind of guy. You know, the Pilgrims didn't come to this country for religious freedom. They came for economic freedom. That's what they came for. And economic freedom to the Pilgrims meant I could own land. So that's really the highest purpose of why this country started, and based on our free economy. And every time our state legislature does something, or local municipalities do something, they're taking away our basic rights, you know? So yes, we have the right to free speech, but we also have the right to own our property and work hard for our own labor. But that's not what we get here. So unlawful detainers. If you want your property back, call me silly. I think you should get it back. I don't care what reason. I own it. I pay the mortgage. I pay the taxes. I pay the maintenance. I want my property back. You're on a month-to-month. If you're on a 4-year lease, sit there for 4 years. You're on a month-to-month, I want it back. Nobody agrees with me. But then again, I'm a guy who thinks that there should be debtors' prisons. You don't pay your debts, you go to jail. Don't you think that's right? Right? They should let you out for 6 months to work and try and pay it back. Do you got the money? No? Back in jail. But again, I'm a little unto myself. Okay, here's some more gotchas. If you have property in the city of Los Angeles and you're under rent control, and you want to win your case, you got to post that sign by the mailbox. It's a one-time thing. Post it by the mailbox and take a picture of it. This is only for the city of Los Angeles, which your property is under rent control. It's on my website, or you can get it online someplace else, but that is on my website. And that is the form that needs to be posted in a conspicuous spot on the premises by the mailbox. Okay? If you don't, and you bring forth an eviction case based on non-payment of rent, and he hasn't paid you in 14 months, you're going to lose. Why? Because that's a gotcha. You didn't post that stupid notice on your property. Now, it's really difficult when you have a condo, because condos can be under rent control of the city of Los Angeles. And the guy is saying, where do I post it? I go, I don't know. Post it by the mailbox. Take a picture. I don't care if someone rips it down, as long as you got a picture of it. Okay, here's another gotcha. Ready? Now, we're still just talking the city of Los Angeles only. And that is, every year you have to register your units. And every year you get one with a new date on it. This one happens to be 2018. And then you're going to get one for 2019. And you're going to get one for 2020 in the city of Los Angeles. You got to register your units. But it's not just enough of registering your units. You got to send them one of those copies. You're going to send them one of those copies. And if you're a rookie attorney representing a landlord in court, the defense attorney is going to get up and say, is your unit registered? Yes. And did you send a copy to the tenant? I don't remember. You lose the case. Just like that, because the tenant's going to say they never got it. And if they never got it, that means there's a defect in your case. I don't care that the guy is shooting up the common areas of the property. I don't care that he owes you 12 months worth of rent. I don't care that he brought in a vicious dog. It doesn't matter. It's one of the gotchas, okay? Now, so for City of Los Angeles, post that notice, and every year mail one to each tenant. Don't post that. Mail one to each tenant. No yawning out there, okay? No yawning. I want to be like you're excited about listening to me, okay? Okay, but let's pretend you don't have property in the city of Los Angeles, but let's pretend you have it in a place called unincorporated area of LA County. What the hell is that, Dennis? Well, there's LA County, but inside LA County you got these incorporated cities like Los Angeles, like Gardena, like Montreux. These are all incorporated cities, right? But then there's lots of little areas that are not incorporated, and those are controlled by the disgusting county supervisors, okay? And they hate you because they created their own rent control. So in those areas, forget the state, you have to deal with the county rent control, okay? So if your property is in an unincorporated area of LA County, you're now under rent control, unless it was a single family residence, okay? Or if it was built was built post February 1995. So let's move on. We have, for West Hollywood, Culver City, and unincorporated areas of Los Angeles, those three areas, if you serve a 3-day notice, and then at the end of the 3 days the tenant doesn't pay you, what do you do next? What do you do next? I'm gonna terminate this seminar right now. You call me. What the hell am I here for? Why do I have that number on my brochure? Okay, but you call me after the end of the 3rd day, okay? But let's pretend it's by the 6th day. You've already lost your case. What? How did I lose my case? Because those ridiculous cities or municipalities or county requires that you serve a copy of the notice on the county or on West Hollywood or in this municipality of Culver City. Those 3 places. Now, for West Hollywood, when you serve a 3-day notice, send one to the West Hollywood Rent Control Board. You're done. If you don't, within 5 days, case lost, which means you have to just serve a new 3-day notice. And that's what we're doing. We're telling them, well, we got to serve a new 3-day notice. But the other 2 places are insidious. Culver City, an unincorporated area of LA County, what they're doing is they're requesting that you first serve the notice, and then within 5 days you have to send to those cities or the unincorporated county, and I have an address where we send it to, a copy of the notice, a proof of service that you served the notice, and that has to be sent, certified mail return receipt requested. What? Another $5 I got to give up here? I might as well buy a Diet Coke out there, right? So I go full circle. Okay, so you have to send one to the county or to the city of Culver City, certified mail return receipt requested with a proof of mailing, a proof of service that you served the tenant, and you have to do that within 5 days. Now, West Hollywood, you just have to mail one to them. I would mail it by certified mail because West Hollywood is really good at lying. Okay, let's move on. A 3-day notice. It's pretty simple to fill out, and that's why everybody makes a mistake, and we all lose our cases. Specifically, if you know, this is true for the entire state, whether you're under rent control or not, but you do have to have the exact amount of rent in the notice. Do not include late charges. Do not include skip charges. Do not include refrigerator charge. I don't care what. It's just rent. Do not include security deposit that he owes you. Okay? You must state the name of a person to who to pay. I have a building that's in an LLC because I think that's smart. And people always name their LLCs like after the address, like 125 Gilmore LLC, right? Right? That's boring. And I'm an attorney. So my building is called Never a Dull Moment LLC, which is great when I go to court and then the judge has to state that Never a Dull Moment versus Johnson. Right? I once had a client named his LLC, this is a true story, he named his LLC, These Pretzels Are Making Me Thirsty LLC. And the judge literally had to call that, he's cracking up as he's saying it. So anyway, getting back to point is your building's in an LLC and it says person to pay. And you write Never a Dull Moment, LLC. But you have to have a name, a human being, not a dog, but a person with a first and a last name. So I do Never a Dull Moment, attention Dennis Block. Okay? If it's just you own the building, obviously that's going to be your name. But if you're that XYZ partnership you have to have at least somewhere on it attention such and such, your first and last name, or someone's first and last name like the manager. You have to have a name of a person. You have to have a phone number on that notice. You have to have an address where to pay. Can it be a P.O. box? Yes. Can you give them a bank account number and an address of the bank and the times that the banks are open? Yes. Okay. Can you say, call me and I'll pick it up? No. Everybody does that. It's no call me and I'll pick it up. We have an address where they can go to. It can be a P.O. box, that's fine. Okay. You must state the date and times when you can pay me. Okay. So Monday through Friday, I have it on my notices, which is in the packet. Monday through Saturday, 9 to 5, whatever, okay? If it's going to a P.O. box, you don't have to have the times because you can mail it at any time, okay? Again, no late fees or skip fees in the notice. So if you're going to construct a proper notice to pay rent or quit before you come to me, and then I'm going to just reject it, just follow this, and I'll say, gee, you did a really good job, and I'm happy for you, okay? All right, let's move on. Keep accurate records in a rent-controlled areas. If you're literally 1 penny off, I kid you not, 1 penny off, you lose. You lose. So when you're doing your rent increases, like in the city of Los Angeles or now in the entire state, and it works out with the rent increase that the rent is now $18.99 and 99 cents. Don't put 1900. Don't round up. If anything, round down, okay? And if you're not sure on your amount of rent that's owed, go less. Take $100 off. The guy owes me $19,200. You know what? Let's just make it 19. Okay, we'll take away $200. You ain't getting it anyway, right? And this way, if you made a calculation, okay, that's incorrect, or sometimes late charges are not proper, so really, they're going to apply that late charge towards the rent, and therefore your 3-day notice is incorrect. So don't make any miscalculations. Never round up on rent increases. And keep, obviously, all repair requests and work that you performed. So they give you that rent repair request. This is for the lawsuit. You want to make sure that you have kept that, and it's nice to do a follow-up letter to the tenant where you say, you know, you asked me on Tuesday to fix the garbage disposal, and on Wednesday I fixed it, and I hope you're happy with the work. And you have that back. So you see this nice list. Now when the guy goes to court and is complaining about all this stuff, look, Your Honor, every time he gave me a written request, I did it within a day. And magically now he doesn't have copies of any of these repair requests. So make sure that you keep accurate records. Last thing I want to talk about is the state legislature, in their ultimate wisdom, has decided to steal more money from you. Does that surprise you? No. What they do is they allow tenants to live longer on your property without paying for it. Why is that? Because now there's a new way to count when the 3-day notice expires. It used to be the day you served the notice was day 0. Then the tenant would have the next 3 days to pay. However, if the 3rd day was a Saturday or Sunday or a legal holiday, then the tenant would get through the next day. So if I served a notice on Thursday, this is the old law, Friday would be day number 1, Saturday would be day number 2, but the 3rd day couldn't be a Saturday, Sunday, so it would slop over to Monday. So if I serve a notice on Thursday, they get till Monday to pay. Okay. Now they've changed it up. None of the days in the 3-day notice period can be a Saturday, Sunday, or a legal holiday. So if you serve a notice on Friday, Friday's day 0. I can't have Saturday be day number 1. I can't have Sunday be day number 2. In that situation, Monday is day number 1, Tuesday is day number 2, and they have until Wednesday midnight to pay you the money. And then, after Wednesday midnight, what do? Call Dennis. Thank God, finally, I got to the end of this speech. All right, so that's the new rules on how to count days. please follow what I'm saying with regard to if you're going to be stuck under the new rent control, please, right now, I don't want anybody crying come January, I should have listened to, don't do that, just do it now, okay? If you want us to help you with the notice, I'm happy to do so. I do want to leave you one story, and then my booth is right behind this curtain here. Like the Wizard of Oz, you can come to my booth, or you can ask me questions until I fall over. Precisely at the end of this conference, when I'm closing down my booth, I guarantee I will be ingesting at least 2, maybe 3 margaritas. Now, this reminds me of a story about an attorney who bought a Ferrari. He's got it on the highway for the first time. What do you think he's going to do? That's right, he's going to speed. So he speeded at 80 miles an hour, 90, 100, 120, 150, gets up to 160 miles an hour. He looks in his rearview mirror and there's a CHP officer, red lights blaring. He thinks to himself, I can outrun him. But then he thinks to himself, I'm an attorney, I better pull over. Pulls over, the CHP officer gets out of the car, walks over to him. What the hell were you thinking about? It's at the end of my shift, I'm going to have to write you up for reckless driving. Are you out of your mind? He says, well, I'll tell you what. If you can give me one good reason why you were going 160 miles an hour, I'll let you go. Well, we're attorneys. We come up with ideas. So the attorney looks at him and says, let me tell you what happened. 2 weeks ago, my wife ran off with a CHP officer. When I looked in my rearview mirror and saw you, I thought you were trying to give her back to me. Thank you very much.